Hello friends, I am Dr. Manoj Kumar Sharma and speaking to you from the platform of Edukemy. See, at mains examination, the biggest challenge for every candidate happens to be one. What will be the appropriate answer to the question that has been asked? It is an essay type examination. In technical words, it is an achievement test where what you have studied for considerably a long period is tested by the way of your theoretical presentation, in terms of evidences, in terms of other things which may be required to be presented. If I talk of GS paper 2, okay, that is what we are discussing, and especially I will be discussing polity and governance questions here. Then what will be the right answer? Like some students have been talking that sir, this time case laws specific questions have been asked. So how do we answer them? Though all those who have appeared and those who are willing to appear next year, you definitely must have appreciated the paper, how the UPSC examiners have framed it. They are actually testing the capacity of the candidate to appreciate the environment, the policies, the laws related to important issues of governance around. Okay? Two types of questions at the examination: 10 marker 150 words and 15 marker 250 words. I will start with a 15 marker and then I will proceed to 10 marker, okay, because this is more popular in terms of UPSC when they are asking this question and touching a very basic issue that will be in any arrangement of separation of parts, and if it is democratic arrangement of separation of parts, it becomes furthermore significant. The question is, friends, discuss the essential conditions for the exercise of the legislative powers by the governor. Then discuss the legality of re-promulgation of ordinances by the governor without placing them before the legislature. So, first part is specifically telling you that how the governor, what will be the conditions where the governor can promulgate ordinances. And then second part is talking about that do you think it is legal to re-promulgate ordinances? So, they are asking about it. If I talk about this question, then you will say, sir, it is around the issue of ordinances. Friend, what is an ordinance? It is an example of executive legislation. Okay? It is an example of executive legislation where executive can legislate. Just for a brief moment, I will take you to Tudor dynasty in England, where this idea of ordinances evolved, and that is why sometimes you must have heard of or written somewhere, you must have seen Henry VIII clause. Henry VIII clause is nothing but a piece of executive legislation which was never presented to the parliament and was never approved by the parliament. How it remained possible at that time was because there was no such condition that the session of the parliament can be called or should be called essentially after a specific period of time. Now in your constitution, you must have seen they have clearly written in both the cases, let it be of president and let it be of the governor, that is at the union level, and then at the state level, it is very specifically provided that the president oblique the governor, as the case may be, shall be responsible for the summon and prorogue of the legislative house oblique houses from time to time, but in no condition, this is to be underlined, but in no condition that time that should be lapsing should not be more than 6 months. Okay? It should not be 6 months in any case. So, it means 6 months minus 1 day and you have to summon the house. So, it means if I see what will be the length of a ordinance maximum, then it will be 6 months minus 1 day plus 6 weeks. That will be the maximum length. Anyway, let us come back to the question you are having the idea. Discuss the essential conditions for the exercise of legislative powers. So, what are the conditions? This is what the examiner is interested in. Article 213, its knowledge will be important because it is a factual presentation. Article 213. In case of governor, the article that is associated with promulgation of ordinances is article 213, okay, that is article 213, that is there, while in case of president beta it is 123. Anyway, let us be back here. So, discuss the essential conditions for the exercise of legislative powers by the governor. It is clearly written in article 213 that governor shall be competent to promulgate ordinances at all the times except for the times when the legislative assembly is in session, okay, and if it is bicameral, then when both the houses are not in session, okay. If anyone is in session in a bicameral, still ordinance can be promulgated. So, legislative assembly should not be in session, that is what we will see for the majority aspect. So, the first condition is legislative assembly should not be in session. If I see condition, then you will be saying legislative assembly shall not be in session. You will be putting it something like this, okay. So, conditions we are seeing. Second, a situation has arisen. What is the purpose of ordinance? As per the constitution, the purpose of ordinance is to bridge the gap, related to legal framework in such situations, in such a condition when framing of law by the legislature is not possible. When the house is not in session, then how the bill can be discussed and how it can be enacted? Very simple. So, it is saying to meet contingencies, it is not a routine and regular thing. It is to meet, the idea is to meet contingencies. Idea is not, so it is not to be used as a routine thing or as a mechanism to bypass legislature, okay. Once again, discuss the essential conditions for exercise of the legislative powers by the governor. How do you start answering it? You will straight away come, it is a 250 words, it is not 150 words, it is a 250 words. So, you will start with ordinance making powers of the governor have been specified under article 213, where it has been clearly provided that governor can promulgate ordinances at all the times except for the time when legislative assembly happens to be in session, okay. Thus, then you will come, next point you will write, thus it can be inferred from the constitutional provision itself that it is a stopgap arrangement, it is an arrangement to meet contingencies. It is an arrangement to meet contingencies in all such situations where it is really necessary to have a legal framework for the purpose of the people, for the purpose of state management. It has become necessary, and then you want to have a law. So, ordinance is allowed. So, you will write it, and you will also specifically write that constitution is not willing to have it in the shape or framework of Henry VIII clause, and that is why constitution has specifically provided for the resummon of the house without the expiry of 6 months, without the maximum expiry of 6 months between the last sitting and first sitting of the next session, last sitting of the previous session and first sitting of the next session. So, it is to bridge the gap, okay. Now, this answer is not possible without judgments of Supreme Court. Why Supreme Court or High Court will be seen necessary while answering such questions? If it is a center state relations question, we always say that from Article 131, because the question will be of original jurisdiction center state relations. So, if you write your answer without mentioning the judgments of Supreme Court, CSRC recommendation, CSRC is Center State Relations Commission's recommendations, then your answer will not be really an answer supported by evidences. Here the question is of constitutional legality itself, it is written, the word is written here legality. So, who is the one who can tell you legality? Of course, courts of law, okay, and the best will be the one who is termed as custodian of the constitution. Who will be the best person? The one who is termed as custodian of the constitution will be the best person to talk about it. Fine. I take you to a famous case, DC Vadhva versus state of Bihar. Okay. It is a very popular case, 1986. There was a professor in Pune who actually went for a case in the Supreme Court is stating that Bihar governor or Bihar government again and again are coming up with ordinances and they are not presenting it to the legislature, and once it is expired they re-promulgate it. So, how far is it correct? When we talk about it, then definitely if I remember 1986, I will always be reminded of Justice Bhagwati, okay, P.N. Bhagwati. Justice Bhagwati in this case, or you may not remember the name of Justice Bhagwati and all, you can straight away, but mention of the case will be of high import. You need to mention the case essentially. It is not possible that you do not mention the case. You will have to mention the case for sure. When we are coming to it, then which cases essentially should be talked about? So, beta, first case that you will be talking about, the second part, discuss the legality. When you are talking the second part of legality, then you need to understand that legality can only be verified and checked by the custodian of the constitution. And who happens to be custodian of the constitution? Supreme Court. See, there will be various cases. Kerala High Court recently talked about, where they have actually referred to DC Vadhva versus state of Bihar, Krishan Kumar Singh versus state of Bihar. So, there will be various cases of High Court also, but essential will be where the custodian of the constitution is laying the rules, laying what will be the real litmus test. Okay. So, the first case that you will talk about will be, it is DC Vadhva versus state of Bihar. Okay. That will be there. You need to remember the words here. Supreme Court in the role of custodian of the constitution to verify legality. By why you are mentioning the cases from Supreme Court only? That is, you need to talk about that why it is like this. Okay? Why it is like this? The case, why are you mentioning this particular case? So, this I told you was about re-promulgation of ordinances, where Supreme Court is specifically observed that re-promulgation of ordinances without placing them before the legislature was violation of the constitution. So, a laid principle, it is now a laid principle that re-promulgation was violation of the constitution. So, The word, see, you have a specific thing, a case which is talking about re-promulgation of ordinances. So, Supreme Court specifically observed that re-promulgation was violation of the Constitution because law making happens to be the function of the legislature only. Okay? So, once again, if I see it till here, one more case you will actually talk about, because this is Justice Bhagwati and others have talked about it. Now, I have a case, Krishan Kumar Singh, another very interesting case from it only, and these two cases essentially should be put or talked about whenever this type of question is there. Krishan Kumar Singh versus, again the state is same, state of Bihar. This was a very interesting case because on it finally a seven judge constitutional bench has given its verdict, and the case started somewhere in 1998-99 and the verdict came as late as 2017. Initially it was a 2-judge bench, then 5-judge, then ultimately 7-judge bench has given actually the decision on it. And if I say the chief architect of the decision on verdict of this case happens to be Justice Chandrachud, okay, D.Y. Chandrachud, who will be Chief Justice of India very soon. So, when I talk about Krishna Kumar Singh versus State of Bihar, what is the case about? The case is about an ordinance that took over the management and control of all non-governmental Sanskrit schools in the state of Bihar. Government of Bihar came out with an ordinance in late 1990s stating that the management and control of all the Sanskrit schools will be with the state government. Krishan Kumar Singh, challenging the legality of the ordinance, went to High Court. High Court, quoting D.C. Wadhwa case, said it was null and void. But then government of Bihar approached Supreme Court, and ultimately, as it was considered it includes question of constitutional validity of such thing and will be laying the ground for all future ordinances and all executive actions in the times to come. It was 2, then 5, then ultimately 7-judge bench, and the judgment was given in 2017. The government said that it was within our power. The Advocate General from the side of state government of Bihar defended the decision of the state government of promulgating an ordinance in regard to this. But ultimately, the judges of Supreme Court stated that it was an established principle way back in 1986 that re-promulgation will be unconstitutional, okay, because you have only one intention at that time, that you want to escape from the test of popular will. Where the popular will is tested? In the popular house, means the legislative house. So, you want to escape from it, and law making is actually the function of legislature and not of the executive. So, a very clear decision came by a 7-judge bench, in 2017, and chief architect was Justice D.Y. Chandrachud. Okay. So, when you are now, you will say that whether the questions of UPSC will be more favoring someone who is having knowledge of law, it is a wrong statement. If some people say it is a wrong one. Knowing the cases, child, you are not talking about the cases of torts, you are not talking about the cases of crimes, you are simply talking about that what is the constitutional validity of certain things which are mentioned in the constitution. Who will actually be talking about the validity, the legal validity of such provisions? Provisions come into action. Now the questions will be raised, are they right or wrong? So somebody has to come and test it, and that test only can be done by the apex court. High courts can also make observations, and you can talk about in March 2022 in Kerala also this a particular case related to ordinance was in question. Okay? So you can talk about it. But more importantly for me, if you ask me, these two cases means UPSC is not asking such things which they expect the students will not be knowing, or it will be favoring someone who is a specialized in it. No, in GS they never ask such questions, but they definitely want also it should not be a superficial idea, yes, ordinance should not be repromulgated. No, they want both. When it is allowed, what are the conditions that it will be allowed? So it is a stopgap arrangement, an arrangement to fill the gap when contingency has arisen to have a law, but it should not exceed beyond the intended time given in the constitution, and then as it is written there, it will cease to exist if not ratified in the state legislature within a period of 6 weeks. So after 6 weeks it shall cease to exist. It will not be, the question is not of that the law is existing, only its operation has been suspended. Cease, CEASE means it will be no more. That is why repromulgation is required. So it is a fresh ordinance. So all this, now we have some idea about it, that how the answer to be written. So 250 words definitely will require, if it would have been 150 words, then you should not have been writing about something Henry VIII clause or other things. Straight away you would have come that article 213 of the Indian Constitution provides for this, 1, 2, 3, these are the conditions, and in regard to legality, Honorable Supreme Court through these cases has actually given its verdict, which clearly provides for that repromulgation will be seen violation of the Constitution. Fine friends. So as I am beginning the discussion, what I expect you that you understand what UPSC is looking for. We are not looking for law specialists, but if it is a paper of polity and governance, surely we want from you that you have good understanding of the environment around. When I talk of a polity question, then polity question when I talk will surely be having certain issues of its application. There we say governance, issue of governor. If it would have been the issue of center state relations related to governor, we would have definitely talked about Sarkaria Commission as well as Punchi Commission, correct? Here also I could have talked about Punchi Commission, but as the question is of legality, so I prefer to talk about the cases given by Supreme Court, okay? Because the question very specifically has been asked about legality. So it means UPSC is not expecting from you that you write some of the answers which are nothing but just mugged up. Somebody has filled it in your head that okay, you go and vomit it. It's not. Because if otherwise I would have written governors, legislative powers, I would have discussed lot of things. But they have said okay, only the conditions. So it means specifically article 213 is required to be known, and then straight away the two cases especially are required to be known, DC Vadhva case and then Krishan Kumar Singh case. Okay friends. So I will take you now to another question. So this was a 15 marker. The nature was philosophical discussion first. What is an ordinance? How it can actually amount to Henry VIII clause. So if I say in Bihar what was operating? Promulgating, repromulgating, 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 and other laws which are required to give effect to such law, ordinances for them also, First promulgation, then re-promulgation. So don't you think it was almost functioning like the Tudor King Henry VIII, who became infamous for neglect of the parliament. Okay? After Henry VII, Henry VIII came, and Henry VIII was actually a bigger despot. He was despotic. So it means when you neglect and ignore the legislature, your rule making can be termed despotic. So that is what we expected in you, that you are aware of these things and you write them.